Hi everyone, and welcome to another podcast. So some of you hopefully might recognise my tones. It's Tina Chander, and I'm the head of employment at WHorld. And I'm excited today for this podcast because I have Adam Morris with me today. So Adam is a solicitor in my team, and we work together daily, but we've never done a podcast together. So it's a first, and we're really excited, because it's also Carers Week. So what have we done? We've dedicated this podcast to Carers Week. And a few months ago, hopefully you have heard of it, but the law gave us special protection. So they introduced Carers Leave. So we've got something new to talk about in Carers Week. So some of you might be wondering, well, what's Carers Week and why have we got it? Before we get into it in a little bit more detail, it's really important to know the stats, actually, because it might come as a little bit of a shock to some of you listening to our podcast today. But, you know, caring for someone can really affect someone's ability at work. And that's not necessarily because they can't perform at work. Naturally, if someone's not at work, it affects performance. But someone's own personal health and well-being. And it's a lot of pressure. It can be a lot of pressure for someone who has the responsibility of caring, and particularly when there isn't a plan in place or the care needs have come about very suddenly. And it's hoped, you know, the introduction of Carers Leave is a positive step. We're going to talk about it in a bit of detail because there are, as you might expect in law, various requirements to meet to the request for leave, but I see it as a positive step. So let's crack on, and let me tell you a little bit about what Carers Leave is with the delightful Adam Morris, who will be doing some speaking in a second. So Adam, now that I've done a little intro for us, please let everyone know, what is Carers Leave?
So, as Tina said, Carers Leave is a new type of leave that's been brought in, and it is for employees to take leave from work to be able to provide or arrange care for a dependent who has a long-term care need. Now, this is a day one right, so from the very first day of your employment, you're entitled to take this leave, which is slightly different to some of the other leaves that have a length of service requirement. So you'll have noticed that I mentioned two key terms there. So the first one we're going to talk about is, what is a dependent? So dependent has been defined within the regulations that have brought this leave into effect. So firstly, the dependent must be the spouse, civil partner, child or parent of the employee requesting the leave. The next thing is that they must live in the same household as the employee and can't be things such as a boarder or a lodger, etc. And finally, they must reasonably rely on the employee to provide or arrange care, which is quite a broad definition, and that's why we're going to talk later on about how employers can help with ambiguity such as that. So the second limb to this is a long-term care need, and thankfully that is also defined within the regulations. So a long-term care need can be any of these three things. So firstly, an illness or injury, whether physical or mental, that requires care for more than 3 months. And anyone that has a disability within the Equality Act. Or finally, any care responsibility that is connected to someone's old age. So that is what Carers Leave is, and I think it's fairly straightforward for employers to follow and for employees to understand.
Yeah, I mean, I agree. It's straightforward. I mean, I suspect there might be some changes to it in the future, because when something's new, it's open to testing. So, I hope that it is utilised, but there are some issues that I can see immediately with care leave, and one of them is that it's unpaid. So, a situation where an employee wants to take time off, and they meet the requirements to take that time off, might feel that actually they don't want to take it off because they can't afford to have no salary for a week. And that has a knock-on effect. We're still all trying to work our way through the cost of living crisis, and quite often people are having or looking to have second jobs. Don't want to go off on a tangent because that's a topic of its own. But, carers leave ultimately is unpaid leave. So we might still find that employees ask if they can take their annual leave instead of carers leave. And ultimately, as an employer, you can grant that. But, annual leave is for rest from work, whether that's going abroad, whether that's staying at home, whether that's spending time with friends and family. It's not necessarily for caring for the individual. But employers should be mindful that the fact that it is unpaid means that it might not be used as the government hoped, because lots of people, in fact, I would say the majority of people simply can't afford to take a full week off. And, I've mentioned a full week. Ultimately, someone might want to take a couple of days, which might be more affordable. But in terms of carers leave, the entitlement is 1 week of carers leave in a 12-month period, which in reality might be sufficient for some people, but it's not really a lot in a 12-month period, particularly if there is a requirement to give, to be with that someone or care for someone for a much longer period. It's interesting actually, because Carers UK have noted that around 9% of people provide care to someone who depends on them. And I mentioned at the start of this podcast that I think it impacts actually the workforce a lot, but it's quite hidden because people keep their private lives quite private. But care it's a start, and I think it's really important that at least employers have in place that policy that says that entitlement exists, and also that employees are aware that that entitlement exists. So one of the questions that we've had already actually come up through just educating our own client base on the new leave is whether more than one if a person has more than one dependent, do they receive additional carers leave? Adam, over to you.
And this is unfortunately an aspect of carers leave that is quite rigid, and some people might think is quite inflexible. So the answer to that question is it's 1 week, no matter how many dependents you have. So, for instance, if you have two elderly parents, both of which have long-term care needs, you would only be able to use your week for those two combined. It wouldn't be for each. But a way in which actually carers leave is flexible to perhaps deal with competing dependent needs is that you don't have to take that 1 week unpaid altogether. So you could have it as one consecutive week, or you could have it as 5 separate periods, or even longer than that if you just wanted to take half days leave. The minimum is half a day. You can take a full day. So in that way, carers leave is quite flexible, but unfortunately doesn't take account of employees that might have more than one dependent.
And I guess, turning back to my point earlier about it's currently an unpaid statutory right for an employee, that doesn't stop an employer from paying enhanced carers leave. Lots of employers will pay, for example, enhanced paternity leave and enhanced maternity leave. So they could look to make carers leave a paid benefit. What I would say to any employees listening, please don't pick and choose who gets paid and who gets unpaid carers leave. It's really important that if you decide that carers leave in your organisation will be paid leave, it applies to everyone. So let's move on in terms of other requirements that need to be met. So notice, I'm sure as an employer, you would appreciate some notice, and actually the leave makes provision for that, doesn't it, Adam?
It does, and thankfully the notice provisions will actually be quite familiar to quite a lot of employers out there, because they match the notice provisions that are required for annual leave. So employees are required to give twice as many days notice as the number of days that they wish to take. So, for instance, if an employee puts in a request, which doesn't have to be in writing, for 2 days of carers leave, they would need to have given 4 days notice of that. The only exception to that is that the minimum amount of notice required is 3 days. So if an employee comes to you and says, I want 1 day of carers leave, they're required to give 3 days. So it's 3 days or twice as long as the period that is required. But as I said, that doesn't have to be in writing, but employers might wish to encourage that as a way of integrating carers leave into their existing systems for requesting leave, which might be through a HR portal or the filling in of a form or something like that they would use for annual leave.
And what about if an employer wants to refuse carers leave, Adam? What's the process there? Can it happen?
It can't be refused, no. So employees can't refuse carers leave at all in any circumstances. But what they can do is postpone that request to a period within 12 months of the originally requested date. But even that is restricted to only when the request would have a serious disruption on the operation of the business. So in the event that an employer does want to postpone a request for leave, first of all, they need to do that in writing, and also they need to give those reasons for why it will have a serious disruption on the business within 7 days of the original request, or sooner if there isn't 7 days notice required.
Mm-hmm. Okay. And then, you know, the requirement to take carers leave, it naturally, it's never really going, I don't see it actually being planned leave unless, for example, someone that meets the definition of dependent is going into hospital and you need to look after them for a week and you know that day in advance. So, you know, there might be occasions where an employee wants carers leave but is unable, because of that situation, is unable to actually give that requisite notice. And what I would say to employers, you know, that might not be ideal from a commercial perspective, but from a moral perspective, and if it is a genuine emergency, you might want to take a different view. But let's remember, carers leave is a new type of leave, so there are still other leaves available for that emergency situation. And there's dependence leave, which is in play, which we're not going to talk about today because I don't want to confuse carers and dependence leave. But employees, if you're listening to this podcast today, you should have provision for that emergency leave in any event. Now, often, you know, requests for dependence leave, and no doubt some requests for carers leave might be to actually look after a child or for childcare purposes. So Adam, what are we saying about that in terms of the current regulations?
Well, that isn't what carers leave is for. In short, carers leave shouldn't be used for general childcare purposes. Technically, that wouldn't fit the definition of why you're required to request it anyway. So for employees that do have childcare responsibilities, their employers should be looking at other ways in which that can be supported. Maybe that is through making them aware of flexible working or hybrid working, home working, that sort of thing, to try and assist parents carry out their contractual duties as well as their childcare duties.
Okay, thank you. And then now an obvious request I would have thought from an employer might be for proof. And actually, you'll be probably surprised to learn that there's no requirement for an employee to provide you with proof. Yeah. What are your thoughts on that, Adam?
I think that's probably a positive step because at the point you start to ask for proof, you're then holding quite sensitive data about people that aren't even your employees. If you're asking for what it is that a dependent has that gives them a long-term care need, and that can bring all sorts of data protection issues, which we won't go into today because it's not, strictly speaking, an employment law issue, but it is important for employers to be aware that privacy notices, data protection policies might need to be updated if that sort of information was being requested. That being said, there is nothing to stop employers from taking a proactive approach, where, as I mentioned earlier on, they have forms in place to allow employees to self-declare as carers, should they wish to, not making it compulsory, so that when that request for carers leave comes in, the employer has been proactive in getting that information to be able to deal with that request sooner.
And, that's, one of the easiest way to have a system in place for employees to, one, know about carers leave, and that includes line managers who often receive requests or HR, because that's a natural place where employees will go to, but they will have to go to line managers as well. It's actually to have a policy in place. So we often think that policies are just for employees. Actually, they're a fantastic guide for employer and employees. So within that carers policy, we will set out all the requirements for an employee to be able to take that carers policy. And also, you can actually create a carers leave form. So there's a form to complete if an employee wants to take it. So I would 100% recommend that a policy is put in place, and they allow for there to be transparency on what that leave is and how an employee can obtain that leave. Really important point to make, as with lots of other family friendly protections, nothing changes in terms of an employee's terms and conditions if they take carers leave. So they remain an employee. There's no gap in their continuous service. There shouldn't be any detrimental impact whatsoever for an employee taking carers leave. And I think it's really important to highlight that, because whilst I hope mistakes like that don't occur, there's always a possibility that, someone takes an alternative view and thinks that there's a break in service, or that an employee is not entitled to something because they weren't there a particular week. Scrap that. None of that applies. They just remain as normal, like every other employee, entitled to their usual salary and benefits, albeit the 1 week on carers leave is unpaid. So I'm just going to finally wrap up this podcast with mentioning types of claims that could be brought, and that might seem a bit extreme, but we are employment lawyers, and we know lots about claims that are brought, and we also defend lots of claims. So just a few seconds to let you know what are the type of claims that can be brought, Adam?
So there are two main types of claim, really, that can be brought. So the first one is employees could issue a claim if they're unreasonably asked or required to postpone their carers leave, or if they're prevented or an employer attempts to prevent them from taking leave. That would be a headed claim in itself. But moving on from that, if an employee was to suffer a detriment or a dismissal as a result of requesting or taking carers leave, then at that point, that is an automatic unfair dismissal without having to go through some of the tests which you may already know. So a detriment might be that all of a sudden they're looked over for a promotion, or they don't get a bonus, or the bonus scheme is skewed in a way that those that do take carers leave are financially suffer as a result of that. So there are many ways in which a detriment could be found. So employers, now this policy and leave is in play, might need to be looking at those sorts of things to make sure that there is no discriminatory effects of those policies.
Yeah. And, as I'm sure all our listeners are aware, an employee can raise a grievance. So if they're not happy with the way you've dealt with something as an employer, or they feel the policy's been unfairly applied, or the employer unfairly rejected a request, or unfairly postponed a request, noting that you can't actually reject one, but let's say an employer that hasn't educated themselves on the new policy does that, grievances can be the start of a long process, and it can result in employees feeling unable to return to work, and all sorts of other claims. For example, constructive unfair dismissal can come out of that. I'm going to stop there because I know I can talk about tribunals a lot more. Maybe that's one for another podcast. But I hope today you've definitely had a bit more knowledge than you did have before you started listening to this podcast on carers leave. And, just to note, carers leave is not a holiday. So those people that are taking carers leave are doing so because someone that they live with, or that someone that's classed as dependent, needs care. So let's always be mindful of that. Well, thank you very much. Thank you to Adam. It's been great having him on the podcast with me. Thank you.